Hello, friends. I welcome you to the important questions, part 2 from MS Act from examination point of view. You may watch any part first. The link to part 1 is given in the description. Let's get started. Next question, which is often asked, is what is special trade passenger, and passenger ships? What are subdivision load lines? What certificates are to be carried by special trade passenger ships? So, part 1. Special trade means the transportation of a large number of passengers by sea within prescribed areas. Special trade passengers mean a passenger carried in special trade passenger ships in spaces on weather deck or upper deck or between decks, which includes pilgrim or person accompanying pilgrim. A special trade passenger ship means a mechanical propelled ship carrying more than 30 special trade passengers. With respect to the passenger ship, subdivision load lines are marked so as to indicate the depth to which the ship may be loaded, having regards to the extent which the ship is subdivided and spaces which has been allotted to passengers. No ship shall be loaded so as to submerge the appropriate subdivision load line in salt water. If she is so loaded, the ship is to be detained until she ceases to be so loaded. A ship which is intending to carry special trade passengers to or from ports within India is required to have been issued a certificate A and a certificate B. Ship intending to carry special trade passengers to India from outside or from India to outside must have the following certificates: a passenger ship safety certificate, an exemption certificate, a special trade passenger ship safety certificate, a special trade passenger ship space certificate, and a certificate B. The custom collector who is to grant port clearance shall not do so unless is carrying the appropriate certificates. Next question is, what are the provisions of MS Act with regards to reporting and communication of intelligence regarding danger to navigation? What are the content of certificate A and certificate B? The answer to this question is very similar to what SOLAS Chapter 5 Regulation 32 says. The master of every Indian ship which encounters dangerous ice or a dangerous derelict, a tropical storm, or any other direct danger to navigation or sub-freezing temperature with gale force, causing severe ice accretion on the superstructure or gale force for which no storm warning has been received, shall inform ships in the vicinity and send appropriate information by all means of communication available to him to the appropriate authority ashore. The appropriate authority ashore, on receiving such, shall as soon as possible communicate it to such ships and authorities as it deem proper. No fees shall be charged to any ship for communication any intelligence as required by this section of this Act. Next question I'm going to discuss is, what is shipping casualty as per MSA Act, then definition of wreck, provisions of MSA Act as per the preservation of life and property of a vessel wrecked on or near the Indian coast. So, a shipping casualty shall be deemed to occur when, on or near the coast of India, any ship is lost, abandoned, stranded, or materially damaged. On or near the coast of India, any ship causes loss or material damage to any other ship. Any loss of life due to any casualty happening to or on board a ship on or near the coast of India. In any place, any such loss, abandonment, stranding, material damage, or casualty occur to or on board any Indian ship and any competent witness thereof is found in India. Any Indian ship that is lost or supposed to have been lost, and any evidences obtainable in India as to the circumstances under which she proceeded to sea or was last heard of. In case of 1, 2, and 3, harbour master or pilot, or in case of 4, the master of the ship on arrival in India shall immediately inform the appointed officer of shipping casualty. Whenever the appointed officer receives credible information of a shipping casualty, he shall inform the central government and may make a preliminary investigation into the cause of shipping casualty and shall send the report of preliminary investigation to the central government. As per MSA Act, wreck is defined as goods which have been cast or fallen into the sea, and then sink or remain underwater. Goods which have been cast or fall into sea and remain floating on the surface. Goods which are sunk in the sea but are attached to floating object in order that they may be found again. Goods which are thrown away or abandoned. A vessel abandoned without hope or intention of recovery. The central government appoints the receiver of wreck, and it is his duty to take all necessary actions for preservation of the vessel and the lives of persons belonging to the vessel and of its cargo and equipment. Such person shall not interfere between the master and crew of the vessel with respect to the management of vessel, unless the master request him to. Adjoining land may be used for providing assistance or landing the vessel cargo, equipment, or person without any interruption by the owner of such lands. Any damage caused by such an act is charged upon the ship, cargo, and equipment by which such damage is caused. The receiver of the wreck may take such steps and use such force as he thinks necessary to suppress any disorder or obstruction of the vessel or shipwrecked person, cargo, or equipment. Another important topic is explain procedures of investigation and inquiry following a casualty, the power of court, and power of marine board. So, after the officer appointed for shipping casualty, he submits the information in writing to DG and may proceed to make preliminary inquiry. After the preliminary inquiry, the report of the same is forwarded to the DG. The officer may, or where the DG directs, shall make application to the court requesting it to make a formal investigation, and the court shall thereupon undertake a formal investigation. The court may take an inquiry in any charge of incompetence or misconduct on the part of master, mate, or engineer. Before commencement of such inquiry, such a master, mate, or engineer will be given a statement of the case upon which inquiry is directed. If the DG has reason to believe that there are grounds for charging any master, mate, or engineer with incompetence or misconduct, may transmit a statement of the case to the court. Before the court commences inquiry, it shall give a written statement to the master, mate, or engineer so charged, giving him opportunity of making a defense. Power of court. If the court thinks it necessary for obtaining evidence that a person should be arrested, it may issue a warrant for his arrest. It may authorize any officer to enter any vessel for the purpose of making such arrest. If found guilty, the court may cause such person arrest or commit him or hold him to bail to take trial before proper court. A certificate of the master, mate, or engineer which has been granted by DG may be cancelled or suspended. By court holding formal investigation into a shipping casualty, if the court finds that loss, stranding, or abandonment or damage to the ship or loss of life has been caused by the wrongful act or default of the master, mate, or engineer. Certificate may also be cancelled by court holding an inquiry into the conduct of master, mate, or engineer if it finds that he is incompetent or has been guilty of any gross act of drunkenness, tyranny, or other misconduct, or in case of collision, has failed to render assistance or give information. Where it appears to the court that cancellation or suspension is not justifiable, it may pass an order censuring the master, mate, or engineer. The judicial magistrate of first class may remove the master of any ship within his jurisdiction if he thinks necessary. Such removal may be made upon application from owner of any ship or his agent or one-third the view of the ship. The judicial magistrate may appoint a new master instead of the one removed. Convening, constitution, and power of Marine Board. Whenever a complaint is made to an Indian consular officer or senior officer of any ship of the Indian Navy in the vicinity, master or any member of the crew of an Indian ship, and such complaint appears to the Indian ship and such complaint appears to the Indian consular officer or naval officer as the case may be to require immediate investigation, or wherever the interest of the owner of an Indian ship or of the cargo thereof appear to an Indian consular officer or naval officer, as the case may be to require it, or a complaint is made to an Indian consular officer or Indian consular officer against the master or any of the officer of an Indian ship. or whenever any Indian ship is lost, abandoned, or stranded at or near the place where an Indian consular officer or naval officer may be, or whenever the crew or the part of the crew of any Indian ship which has been lost, abandoned, or stranded arrives at that place, or whenever any loss of life or any serious injury to any person has occurred on board any Indian ship or near that place, the Indian consular officer or naval officer, as the case may be, may in the direction convene a board of marine inquiry to investigate the said complaint or allegation or the matter affecting the said interest or the cause of loss of abandonment or the stranding of the ship or of the loss of life or of the injury to the person. Constitution of a Marine Board. A Marine Board shall consist of the officer convening the board and two other members. The two other members of the Marine Board shall be appointed by the officer convening the Marine Board from amongst the person conversant with maritime or mercantile affair. The officer convening the Marine Board shall be the presiding officer thereof. Now, the powers of Marine Board. A Marine Board may, after investigating and hearing the case, if it is of opinion that safety of an Indian ship or her cargo or crew or the interest of the owner of the Indian ship or of the owner of the cargo thereof requires it, remove the master and appoint another qualified person to act in his stead. A Marine Board may, if it is of opinion that any master officer of an Indian ship is incompetent or has been guilty of any misconduct, or in case of collision, failed to render assistance, or that loss, abandonment, or stranding of or serious damage to any person has been caused by the wrongful act of default of any master or ship officer of an Indian ship, suspend the certificate that master or ship officer for a stated period, provided that no such certificate shall be suspended unless the master or officer concerned has been furnished with a statement of the case in respect to which investigation has been ordered, and he has also been given an opportunity of making a defense either in person or otherwise. The court may discharge a seaman from an Indian ship and order the wages of any seaman so discharged, or any part of those wages, to be forfeited. The board may decide any question as to the wages, fines, or forfeiture arising between any of the parties to the proceeding. The board may direct that any or all of the incurred by the master or owner of an Indian ship or on the maintenance of seamen, apprentice while in prison outside India shall be paid out and deducted from the wages of that of seaman or apprentice, whether earned or subsequently earned. A board may, if it considers such a step expedient, order a survey to be made of an Indian ship which is subject to investigation. The board may order the cost of proceeding before it or any part or those costs to be paid any of the parties thereto, and may order any person making frivolous or unjustified complaint to pay compensation for any loss or delay caused thereby, and any person shall be paid by that person accordingly and may recover in the same manner in which wages of seamen recoverable, or may be deducted from the wages due to that person. All orders made by a Marine Board shall, where practicable, be entered in the official logbook of the ship which is subject of investigation or on board which the casualty or occurrence or the conduct investigated took place, and be signed by the presiding officer of the board. Another common question is, what is master's obligation as per MSA Act with regards to assisting a vessel in distress? Every master of an Indian ship at sea, on receiving a distress or information that another ship or aircraft is in distress, shall proceed with all possible speed to their assistance, informing them if possible that he is doing so, unless he is unable to consider it unnecessary in the given circumstances and is released from his obligation to do so. If the master of an Indian ship who has answered the distress call is requisitioned, then he shall proceed to the assistance of the other vessel with all possible speed. The master of the requisitioned ship is released from the obligation to proceed to the assistance of the ship in distress if he is informed so by the person in distress or by the master of another ship on site that his assistance is no longer required. If the master of an Indian ship is unable to proceed for the assistance of a ship in distress, he shall make a statement to that effect in official logbook, stating his reason for not doing so. Entry shall be made in the official logbook of every distress signal received. Next part of master's obligation in case of a collision is, in every case of collision, it is the duty of the master, if he can do so without danger to his own vessel, crew, and passenger, if any, to render all assistance to the master, crew, and passenger of the other ship so as to save them from any danger caused by collision, and to stay by the other ship till he has ascertained she has no further need of assistance. And then he should give to the master of the other ship the name of his own ship, his own ship's port of registry, the next port of call, and the last port of call. The master must make an entry in the official logbook of the collision and the cause of the collision, inform the nearest principal officer, vessel name, official number, port of registry, and present location. Another question that may be asked in the orals is, what are duties of a master under MSA when the vessel meets a major accident? So, under both MSA and international law, it is the duty of the master to ensure seaworthiness of his own vessel. And if the accident is due to collision, he should follow the same procedure as mentioned in the previous question, which is first ensuring that safety of his own ship, then render assistance to the other ship, and then inform the master of the other ship, port of registry, last port of call, next port of call, and then make the required official logbook entries. And where Indian ship has sustained or caused an accident which results in loss of life or serious injury, or which affects her seaworthiness, or her hull or machinery in any part of the ship is so altered that she does not correspond with the particulars in any certificate issued under MSA, the owner or the master of the ship shall inform the DG or PO within 24 hours of the occurrence or as soon as possible, and thereafter send the details of the accident, stating ship's name, official number, port of registry, and present location of the ship. The master must keep in his duty to ensure that the ship is seaworthy, and to this effect he shall inform the owner, charterer, and underwriter. At the vessel first port of call after the accident, the master should arrange for a survey of the vessel. The master must also note a protest, reserving his right to extend the protest. Ideally, the vessel should be surveyed by a classification society surveyor, and if he finds the vessel fit to proceed on a voyage, he can grant a certificate to this effect, or he may issue a qualified certificate stating that ship be dry docked for further examination at the named subsequent port. Such a certificate is called interim certificate of class. The surveyor shall forward his report to the committee of the classification society. If the classification society surveyor is unavailable, the master may consult the Indian consular officer. If the services of another surveyor are used and he is satisfied that the ship is seaworthy to complete her voyage, he will issue a certificate of seaworthiness. In this case, it is imperative that the vessel be surveyed by the classification society surveyor at the earliest opportunity when no qualified surveyor is available. The master of the damaged vessel may request two masters of any ship to carry out the survey, and in case of machinery damage, the survey should be carried out by the shipmaster and a chief engineer. In this case also, the master must cause a survey to be carried out by the classification society surveyor at the earliest opportunity. In case the vessel has undergone repairs, the underwriter should be informed so that they can carry out a survey as required by the tender clause of the marine insurance policy. Failure to do so may result in a 15% deduction from the bill of repairs by the underwriters. With regard to the certificate of seaworthiness or interim certificate of class, it is important to note that if master fails to obtain such a certificate and any loss or damage to the vessel, machinery, equipment, or her cargo takes place, then not only will the vessel lose her right to insurance, but will also be unable to take protection under the exception clause of the contract of affreightment. Next often asked question during orals is, explain the procedure of registration of an Indian ship. So registration of an Indian ship is required only for seagoing ships fitted with mechanical means of propulsion and every ship greater than 15 net tonnage employed in navigation on the coast of India. So the procedure is, Registry shall be made at Mumbai, Kolkata, Cochin, or Chennai, or at any other port as central government may notify in the official gazette. The principal officer shall be the registrar of Indian ship at that port, and in his absence, the senior most surveyor. Application for registry must be made by the person requiring to register as the owner or his agent. In case of agent, authority of the same shall be testified. The owner must arrange for the ship to be surveyed by a surveyor. The surveyor shall grant a certificate specifying tonnage and other particulars describing the ship, and this certificate is then delivered to the registrar. Based on the information provided by the surveyor, a declaration of ownership shall be prepared and attested, which shall contain a statement if he is not an Indian citizen, then a statement of time and place the ship was built, or if built outside India and the time and place is unknown, a statement to that effect. Name of the master. If the ship was earlier registered outside India, a statement of the name under which she was registered. Finally, a declaration that the information provided is accurate. Along with the declaration of ownership, a builder certificate signed by builder shall be submitted which contains true account of tonnage as estimated by builder, time and place of build, name of person whose account she was built, instrument of sale. The owner of a ship requiring its registry shall have the ship marked permanently and conspicuously in a manner prescribed by the registrar. When all the above is completed successfully, the registrar shall make an entry in the register and enter the following: name of the ship, port of registry, details in the surveyor's certificate, particulars of origin from builder's certificate, name and description of registered owner. On completion of registry, registrar will grant the certificate of registry containing all the particulars in the register and name of the master. Next question is, what is the significance of certificate of registry? Certificate of registry is the most important document required for trading and obtaining custom clearance. On the basis of certificate of registry, ship is entitled to privileges and subject to obligation of Indian flag. Enables the ship to fly the flag of the country she is registered with. She is obliged to follow the law of the country of registry. Shows that the master is lawfully appointed by the port of registry. Certificate of registry is issued under UNCLOS and Geneva Convention on the Registration of Ship. I hope this series is useful to clear your exams. Thank you for listening.